Hello, welcome back to Learn Oikonomia. In this video, we are going to look at a very important topic, the Right to Information Act 2005. Just to understand the historical background of this act, we have to understand that the right to information is considered to be a fundamental right under Article 19(1) of the Indian Constitution. In 1976, what has happened is that in the Raj Narayan versus the state of Uttar Pradesh case, the Supreme Court has ruled that the right to information would be treated as a fundamental right under Article 19. The Supreme Court also held that in Indian democracy, people are the masters and they have the right to know about the working of the government. So, as a result, what has happened is that the government has enacted the Right to Information Act in 2005, which would be providing the machinery for exercising this fundamental right. Let's understand the main basics of Right to Information Act of 2005. This is considered to be one of the very important acts which would be empowering the ordinary citizens of the country to question the government and its working. That means that this act provides some right to the public or individuals or citizens of the country to question the government, to question the working of the government if they see that the government is not working properly. So this act has been widely used by citizens as well as media in order to uncover certain problems in the economy like corruption, whether the government is actually progressing with the certain work of the government is also a question with this act. And also the public, the media, etc. could be able to get the expenses related information or the expenditure made by the government by using this act. All the constitutional authorities, agencies owned and controlled also are on would be coming under this act. All the organizations under the government would also come under this act. So this act mandates public authorities of union government or state government to provide timely response to citizens' requests for information. This act would be imposing penalties if the authorities makes any kind of delay in responding to the citizens in the stipulated time. How can we request some information through RTI? The citizens actually, they can seek any information from the government authorities that the government can disclose to the parliament. So we have to see that this act gives entire right to citizens to demand certain information from the government if they want the government to provide for information. So what all information the government disclose to the parliament, they are answerable to the public as well. If the public demands such kind of information to be published, or published in the sense that if the public demands such kind of information to be made open to the public, the government has the entire responsibility to make it public. Some information that can affect the sovereignty and integrity of India is actually exempted from the purview of RTA. So these information, even if the public demands such information from the government can say that the government has no right to reveal these kinds of information to the public. So some information the government can withhold with them by saying that the government can withhold certain information by saying that they have no responsibility or they have no right to disclose these kinds of information, because these information, if they reveal, would be affecting the sovereignty and integrity of the Indian economy. Information related to the internal security, those related to the foreign affairs, those related to the relation of India with the foreign countries, those related to individual property rights, cabinet discussions and its responses. All these kinds of information are actually very much important for the sovereignty and integrity of the nation, and thus these information are exempted from the Right to Information Act. Let's see the objectives of Right to Information Act. This right would be empowering the citizens to question the government, to question the working of the government, and that this act promotes transparency, accountability, etc. in the working of any government, and this would be helping in containing certain problems in the economy like corruption, black money, etc. So if this act is implemented, this act is already implemented, so if it works properly, what happens is that this will help the people in a very much better way so as to make them empowered, which would be helping in the development of the nation. And this act envisages building better informed citizens who would keep necessarily vigilant about the functioning of the government machinery. What are the provisions under the Right to Information Act? We are not covering all the provisions of this act, but let's discuss some of the important provisions. Section 2H discusses the public authorities mean all authorities, bodies under the union government, state government or local bodies. So the civil societies, they are that are actually that are substantially funded directly or indirectly by the public funds also fall within the ambit of RTA. So here we can see which all are the entities, which all are the authorities which come under the Right to Information Act. This is what is discussed in section 2H. So under the 4.1b, here it is said that the government has to maintain and proactively disclose the information. That means that government has got the entire responsibility to disclose the information if there is any demand from the public to get such kind of information. Section 6 says that it prescribes a simple procedure for securing information. That means that we know that usually, especially in the absence of these kinds of provisions or these kinds of acts, if any of the public citizen or if any of the citizen needs any kind of information from the government, it is really a tedious task and a timely procedure. But in the presence of this kind of an act, it actually makes the process simple. It makes the process less time consuming. So the citizen can get the information with less time, with less cost, with less effort. Under section 7, it prescribes a time frame for the providing information by PIOs. That means that the government cannot take too much of time to give information to the public. If there is any kind of demand from the public to get the information, that time would be specified. So the government should meet the deadline, and within that deadline, within the last day, the government should give the information to the public. It should disclose the information. Under section 8, it is said that only minimum information is exempted from. So section 8 says that only minimum information is accepted from disclosure. We have seen that certain information which would affect the sovereignty and integrity of the nation are actually exempted from this act. So even if the public demands such information from the government can tell them that these information cannot be revealed by substantiating that these are actually affecting the sovereignty or integrity of the nation. For example, the defense areas related to defense or aspects related to defense or information related to defense. So information related to defense, relationship of the nation with other countries, all these things are actually exempted from the disclosure of Right to Information Act. Section 8.1 says that it actually mentions that certain exemptions against the furnishing information under RTI Act. This is something related to Section 8. Section 8.2 provides for disclosure of information exempted under the Official Secrets Act 1923 if the larger public interest is served. Again, something related to Section 8. Section 19 says the two-tier mechanism for appeal. That means that there is a two-step procedure mechanism for going for an appeal. Now, Section 20 provides penalties in the case of failure to provide information on time, incorrect, incomplete, or misleading, distorted information. That means that the public asks for information, the public demands for information, but the government, if they makes any kind of delay or if they provides incorrect information or incomplete information or misleading information, that means that, or if they provide any kind of distorted information, that means that it actually invites penalties. Next, Section 23 says it deals with the lower courts can be barred from entertaining suits or application. However, the writ jurisdiction of the Supreme Court of India and High Courts under Article 32 and 226 of the Constitution remain unaffected. So, these articles, as per these articles, certain jurisdiction of the Supreme Court of India and High Courts would remain unaffected. What is the significance of Right to Information Act? Especially, we know that India is a developing country. India is actually trying its level best to attain the developed world status. So in this scenario, what is the significance of Right to Information Act 2005? We have already said that this act would be giving empowerment to the local public or citizens in the economy, so that they can question the secrecy of the government. If there is any kind of abusement of power or abuse of power in the government level, the public can question the government, the media can question the government. It is through this act the various central government and state level authorities are answerable to the public, and this act can be regarded as a public good because it is relevant to the interest of citizens and is considered to be a crucial pillar for the functioning of a transparent and vibrant democracy. This act as actually this information obtained not only helps in making the government accountable but also useful for the purposes which would serve the overall interest of the society. Every year around 6 million applications are filled under this act, and so this would make it most extensively used sunshine legislation globally. These applications seek information on a range of issues, from holding the government accountable for the delivery of basic rights and entitlements to questioning of the highest officers of the country. Using this act, people have sought information that the governments would not like to reveal, as it may expose corruption, human rights violation, wrongdoings, etc. by the government. The access to information about policies, decisions, actions of the government that would be affecting the lives of citizens is considered to be an important instrument to ensure accountability. The Supreme Court, it has made several judgments held that it held that data is considered to be a fundamental right flowing from Article 19 and 21 of the Indian Constitution, with guarantee to citizens the freedom of speech and expression and right to life respectively. What are the recent amendments which have come in Right to Information Act 2005? We have seen that this act came into being in 2005, but after its arrival, there have been many additions, many deductions, etc. happening in the act, which is known as amendments. So the Right to Information Amendment Bill 2013 has happened. As per this, it removes the political parties from the ambit of the definition of public authorities and hence from the purview of Right to Information Act. That means that the political parties has no responsibility as per the Right to Information Act to reveal certain information if it is demanded by the public. So actually they are answerable, but under this act, political parties won't come. The draft provision 2017, which provides for disclosure of the case in the case of death of applicant, can lead to more attacks on the lives of whistleblowers. That means that again in 2017 there was a amendment. In 2018 also there was an amendment which aimed at giving the center the power to fix the tenures and salaries of the state and as well as central information commissioners, which are statutorily protected under this act, and the move will dilute the autonomy as well as independence of CIC. The act proposes to replace the fixed 5-year tenure, which with as much prescribed by the government. Even though we have seen that it has got the Right to Information Act of 2005 has got many advantages, the act is not free from criticisms. The act is criticized by many based on many aspects, many leakages, many problems with respect to this act. One of the major setbacks of this act is that poor record keeping with bureaucracy result in missing file, and that means that there is a problem with respect to record keeping, and also there is a problem with respect to missing of files, and also there is lack of staffing to run this information commission. The supplementary laws like Whistleblowers Act is diluted, so this would be reducing the effect of Right to Information Act. Since the government does not proactively publish information in the public domain as envisaged in the Act, this leads to an increase in the number of RTA applications. And also we could see that there have been reports of problems with RTA applications, and also information obtained have been used to blackmail the government authorities, which itself is a problem. So having discussed the criticisms, let's see the challenges of Right to Information Act. We can see that different types of information are sought which has no public interest, and sometimes this can be used to misuse the law and harass the public authorities. For example, you can see that asking for desperate and voluminous information is a problem. So here we have seen that if there is any request or there is any demand for information is there, the government has to provide timely information, correct information, uh, the needed information. So if there is any problem with the supply of these kinds of information, that would attract penalties. So asking for desperate and voluminous information would create a problem with the supply of information. To attain publicity by filing RTI, many people are actually they would just try to fool the government, and for the sake of getting publicity they will file an RTI. Just to trap the government they will file an RTI. So these kinds of problems is considered to be some leading to harassment, and this would be pressurizing the public authority, wastage of time of the public authority, and because we could see that because of illiteracy, unawareness, etc. of the majority of population in the country, RTI, exercising of RTI is something which is very difficult. Though RTI's aim is not to create grievance redressal mechanism, the notices from Information Commission often spur the public authorities to redress grievances. What is the difference between right to information and right to privacy? This is very important to ask. Just see the difference here. The right to privacy and right to information both are essential rights given by the government to the public. So, especially in the modern society where technological information breach is very common, we have to understand the importance of these types of rights, and these two rights complement each other in holding government accountable to the individual in a majority of cases. Right to information would provide a fundamental right for any person to access information held by the government bodies. Right to privacy grants individuals a fundamental right to control the collection of access to and use of personal information about them that is held by the government and private bodies. Right to Information Act versus legislation for non-disclosure of information. We have seen that certain information which would be affecting the sovereignty, integrity of the nation cannot be disclosed to the public, even if there is a demand from the public to reveal that kind of information. So, we have discussed certain topics which is not revealed to the public, which are not revealed to the public. So, some provisions of the Indian Evidence Act provide to hold the disclosure of documents. Under these provisions, head of department may refuse to provide information on affairs of state and only swearing that is a state secret will entail not to disclose the information. In a similar manner, you can see that no public officer shall be compelled to disclose the information or communication made to him or her in official confidence. The Atomic Energy Act, for example, this Act of 1912 provides that it shall be an offence to disclose information restricted by the central government. That means that if these kinds of information which would affect the integrity, sovereignty of the nation, if it is disclosed, that is actually what? Going against the law. It is actually kind of going against the law. So the Central State Servants Act provides a government servant not to communicate part with the official documents except in accordance with the general special order of the government. The Official Secret Act of 1923 provides that any government official can mark a document as confidential so as to prevent its publication. So with that, just understand what Right to Information Act in a nutshell. The Right to Information Act has not achieved its full objective due to some of the impediments created due to systematic failures. We know that we have to protect our social justice, transparency, etc. to make an accountable government. To this law, in this scenario, it provides us with priceless opportunity to redesign the process of governance, particularly, especially at the grassroots level where there is interface is maximum. So it's an interface is maximum. It is well recognized that the right to information is very much necessary, but it is not a sufficient condition to improve the governance. There is a lot to be done to assure the accountability in governance, including protection of whistleblowers, decentralization of power, fusion of authority, accountability, etc. at all levels. As it is observed by the Delhi High Court, misuse of RTA has to be appropriately dealt with, because it is very important, it is very difficult to establish the working of this kind of act, especially in a country like India, which is not only developing with respect to development, but also with respect to population. It is very it is occupying a highest position. So in this populous country, we have to be very careful in dealing with these kinds of acts. Otherwise, the public would lose faith and confidence in this kind of sunshine.